Hello, my name is Reggie Mabry, and this is part two of my analysis of the Securities and Exchange Commission's case against Ripple Incorporated, Bradley Garlinghouse, and Christian Larson. So this is part two. The Securities and Exchange Commission case against Ripple will be dismissed. A 12B6 motion, in my opinion, is warranted to dismiss the case. The SEC case against Ripple fails the same way as the Cohen case. So this is part two of my pro se analysis against the Securities and Exchange Commission against Ripple, the company. Again, I want to say that I am a former pro se litigant, that I am interested in the law, and I am certainly interested in the Securities and Exchange Commission case against Ripple, the company. And I think that the Securities and Exchange Commission has created a nothing burger suit. Not My take is that the suit in itself, of course, will be dismissed. Possibly in the judge's ruling, when we get to a fact finder, we will find that the Securities Exchange Commission about Ripple being a security will be moot, because the case will be dismissed right off the back, and that the Securities and Exchange Commission will lose its opportunity to resue Ripple, the company. And so during this process, that I am thinking that there will probably be some type of settlement, or Ripple, the company, will be immune. And so let's start. I am so happy that my last tweet, I am so happy that my last tweet on the Securities Exchange Commission is out of time on the Ripple suit has gotten some traction. Digital asset investor who, between him and Digital Perspective and the rest of the great YouTube channels, I can't live without. But Digital Asset Investor, in his last show, XRP buyback / exchange / redeem scenario and Ripple becomes waves, posted the elements of a tweet that I put out on December 25th. So I put out a tweet on December 25th on the Securities Exchange Commission is out of time. And here you can see on December 25th, the Securities Exchange alleges from at least 2013 through the present, defendants sold over 14.6 billion units of a digital asset called XRP. And I posted this from Paul Weiss, and so I am so happy for all of those in the community that watch Twitter and can get out the news faster than I can. So shout out to Barry M. Calpin, who found this tweet that I did. And so the first tweet was on December 25th, which I just read. I also put out another tweet on December 25th, saying that the SEC enforcement actions are subject to a 5-year statute of limitations. The SEC knows this, and Ripple knows this, watching 2012 and filing 2020. That is a problem. So the Securities Exchange Commission, in its complaint, says it's been watching activity since 2012, and then they filed in 2020, and that is the 8-year time that will certainly find its way into hopefully a 12B6 motion to dismiss to dismiss the Securities Exchange Commission in its entirety. And today, earlier today, I posted another follow-up tweet, which I have been doing YouTube videos on this. So I've been going over it on my YouTube channel, and it says time is not on the side of SEC versus Ripple. The SEC, by stating that Ripple allegedly engaged in its violations in 2013 or earlier, is time barred. The SEC knows this and still filed its suit. It harmed XRP investors. Their suit should be DOA, dead on arrival, under a fact finder. And I tweeted this to Stuart Alderati and 4 others, and so, but Ripple legal team already knows this. Security Exchange Commission already knows this. The Supreme Court already knows this, but yet the market is still spooked. So let me go on with this presentation, which I am going to talk about this particular case. Time is not on SEC side. EDNY issues new statute of limitations, ruling in the wake of Kokesh. And we're going to go over this case, SEC versus Cohen. And this is an incredible dismissal where a company supposedly engaged in activities from 2007 and 2011, and the SEC filed its complaint in 2017, and the suit was dismissed in its entirety. So let's just take a look at this and see where it goes. I want to bring back some of the issues that Stuart Alderati, Ripple's chief counsel, said. And these are the experts. Stuart Alderati is the expert, and the reason why I'm making these videos is for information and entertainment purposes. I am not trying to sway one way or another what Ripple, the company, and their legal team will do, because they are certainly the experts. But because the issues are out in public, and the Securities Exchange caused so much fear in the market, and there are so many investors in XRP that are spooked, I just want to do my part to help the investors like myself in XRP to get access to some more information to help them during these trying times. Many of us have held XRP for maybe 2 to 3 years or 4 years. Some people bought in recently, and people have panicked, and the Securities Exchange Commission has created an environment where investors in XRP, in cryptocurrency, has lost an enormous amount of money, and there's been an enormous amount of damage to the crypto market, because if the Securities Exchange Commission can do this to Ripple's a company, a holder of this important asset, the companies around that hold XRP are also in fear. And so some exchanges, as you know, are thinking about delisting it. Investors in XRP are spooked that their crypto may be delisted from big exchanges like Coinbase, and I think that Bitstamp has delisted it. People are spooked that MoneyGram may stop using the crypto asset. And so there is a lot of confusion in the market. But Stuart Alderati said, reminder, the Securities and Exchange Commission complaint only alleges. Nothing has been determined. That's what courts are for. That's it. That's the tweet. He said, seeing lots of tweets spreading misinformation, legal and otherwise. Here are some facts. 1. First line of the Securities and Exchange Commission complaint alleges from at least 2013, years before the DAO report, yet the complaint was not filed for 7 years and the day before the chair leaves office. This is extremely important what this attorney has said, because he is certainly looking at the time in which the Securities and Exchange Commission filed its complaint. And anybody who has been involved in a legal suit, have waged a legal suit, knows something about suits being time barred. So the first thing anybody would look at is look at all the elements that you would have to make to do a particular suit. Make sure that you're suing the right entity, looking at the jurisdiction, and looking at issues of it being time barred, and making sure that complaints or cannot be attacked for conclusions, for labels, for allegations that can't be substantiated, and then to look at what might be the defenses of the entity to the defense, up to the prosecution of a complaint. And that would be in the defendants. In this case, the defendant is Ripple, the company, Bradley Garlinghouse, and Christian Larson. And they will, in a short time, within the next possibly 30 to 60 days, they will have an answer to the complaint from the Securities and Exchange Commission. They will list their affirmative defenses, and then they will possibly create a motion to have the some of the issues dismissed right off or narrowed by the court before the suit begins to the next phase, which would be the timing and discovery. So this particular video is looking at the issue of whether or not the Securities and Exchange Commission is time barred, and it is. And so it should be dismissed. The other thing that Stuart Alderati said, there's no fraud or misrepresentation claims. There is one legal question. Did certain of Ripple's distributions of XRP constitute an investment contract? We look forward to litigating that in court and providing the industry the clarity it deserves. So that issue may not actually be litigated if the suit itself is time barred. So if the Securities and Exchange Commission suit is time barred as it pertains to Christian Larson and Bradley Garlinghouse, who's the Securities and Exchange Commission sued as in their individual capacities, if the actions are before the 5-year statute of limitation, then whatever happened to Bradley and to Chris Larson may not have any bearing on anything. The other issue is, of course, I am tweeting information. The Ripple company may feel that I may fall into the category of. So the first thing that I want to bring to the audience is this case. So let's just bring this up. So this is a description of a case and or an article, and this is an alert to the industry. Time is not on the Securities and Exchange Commission side. ED New York issues new statute of limitations ruling in the wake of Kokesh. So in this particular case, on July 12, 2018, the U.S. District Court for the Eastern District of New York dismissed as time barred a civil complaint by the Securities and Exchange Commission against two hedge fund managers accused of a sprawling scheme to bribe various public officials in Africa. Securities and Exchange Commission versus Cohen, and that happened in July 12, 2018. Then they say, while the allegations focused on activity that took place between 2007 and 2011, the Securities and Exchange Commission failed to file a complaint until January 26, 2017. The oldest transaction identified in the complaint allegedly took place in Libya when it was under the rule of Colonel Muammar Gaddafi. One of the defendants was alleged to have met with a son of the Colonel Gaddafi who had influence in the Libyan Investment Authority. The complaint stated that a $375 million deal fee was charged in connection with the decision by the Libyan Investment Authority. The most important part of this is that the actions took place in 2007 and 2011, but the Securities and Exchange Commission filed their suit in 2017. So the last issue was in 2011, and they filed in 2017. So they go on to talk about what rules that they actually have to apply to in determining if this suit would go forward or would be dismissed right off. And then there are issues of disgorgement actions. And so in this case, with the Securities and Exchange Commission against Ripple, they are accusing Bradley Garlinghouse and Christian Larson as basically schemers, thieves, and that they are attacking their personal wealth and possibly could attacking other matters that could possibly lead them in jail. And maybe not. Maybe that's not what they're doing. But the fact of the matter is that they have attacked them in their individual capacity and have made these innovators look like they were petty thieves, and that these technical experts or business owners who are trying to create a useful utility-based cryptocurrency, they are attacking innovators in the United States. So this is problematic, but let's just continue on looking at why this particular case was dismissed. So the Securities Exchange argued that claims against the defendants were timely because it has entered into tolling agreements with the defendants where both parties agreed to extend the statute of limitations. The court disagreed. While there were tolling agreements in place, their terms clearly applied to only 2 of the 9 transactions identified in the complaint. Both of those transactions occurred in Libya, and the tolling agreements themselves had expired by their own terms by the time the complaint was filed. Importantly, the court held that the tolling agreements only told the statute of limitations for actions that arose out of the Libyan investigation, but not additional investigations that were commenced because of the facts learned during the Libyan investigation. Finally, the court rejected the argument that the statute of limitations clock restarted every time the defendants received ill-gotten gains as a result of the allegedly corrupt transactions. Rather, it held that the statute of limitations clock begins to run when the claims fully accrue, meaning when the defendants engaged in the misconduct, not when they received money attributable to that misconduct. Since the claims had fully accrued more than 5 years before the SEC filed its complaint, the court dismissed the SEC's claim as time barred by 28 U.S.C. section 2462. So now what we want to do is we want to actually look at the case itself. So let's bring in the case itself. And we want to look at this based on its construction and some of its arguments. Okay, so here's the case. Securities and Exchange Commission, plaintiff is the plaintiff versus Michael L. Cohen and Banja Barros, the defendants. And again, it's July 12, 2018. This is all important because the Securities and Exchange Commission has had cases dismissed before. And some of these cases were sensational. In this particular case, this is internationally sensational case because it has foreign influences. It's global. And Ripple, the company, is a global company. And most of the XRP holders are probably outside of the United States. Most of the transactions are global out of the United States. So there's some similarity only in the issue that this is a global matter. So here is the order, memorandum and order by the United States District Judge. The Securities and Exchange Commission, SEC, alleges that between 2007 and 2012, defendants Michael L. Cohen and Banja Barros orchestrated a sprawling scheme to bribe various African public officials in exchange for businesses in their hedge fund management firm, Ziff Capital Management. The SEC also alleges that defendants defrauded Ziff investors and potentially investors, evaded OZCM's internal controls, and aided and abetted OZCM's failure to keep accurate books and records. Defendants moved to dismiss the Securities and Exchange Commission's amended complaint for failure to state a claim upon which relief can be granted. Barros also moves to dismiss the amended complaint for a lack of personal jurisdiction over him. Cohen, let's just get to the part. Okay, so these are the particular documents that were filed. For the reasons that follow, the court grants with defendants that the Securities and Exchange Commission's claims are time barred, and therefore grants defendants motion to dismiss the complaint for failure to state a claim. So let's look at the construction. Here is the background, the factual background. These are the elements that were looked at. The Libyan Investment Authority investment, the Libya real estate project, the $86 million loan and $20 million payment, the $150 million DRC mining company stake, the $124 million convertible loan, the $130 million margin loan, the $77 million stock transaction, the Republic of Congo off-field transaction, this is deep, the London Holding Company transaction, and then there's the procedural history of the complaint. And in the Ripple case, there will be a procedural history. The procedural history would be the beginnings of the XRP, would be the beginnings of the company, it would be the formation and reformation of the Ripple company. It will be any actions, for example, financial crimes or enforcements, any reporting, any of that. And it would also, all of these would have time issues based on when these things happen. So many people who have looked at the Ripple company knows that at some point they got a fine for something that the FinCEN saw that was not correct, and then Ripple entered into some type of a fine and agreement and some reporting, and not going to go into the dates of that, but the dates in fact do matter. So in the legal standard, a 12b6 motion tests the legal adequacy of the plaintiff's complaint. To survive a 12b6 motion, the complaint must contain sufficient factual matters accepted as true to state a claim of to relief that is plausible on its face. Ashcroft versus Iqbal, Bell Atlantic Corp versus Twombly. We talked about that in the last video that I did. In considering the sufficiency of the complaint, the court accepts all well-pleaded factual allegations in the complaint as true and draws all reasonable inferences in the plaintiff's favor, right? So in this case, the plaintiff is the Securities and Exchange Commission, and they are going to accept all well-pleaded factual allegations as true and draws all reasonable inferences in the plaintiff's favor when being attacked by a 12b6 motion to dismiss. So if Ripple, the company, decides to lodge a 12b6 motion to dismiss, then we see that some of the allegations of the plaintiff can hold, but that's if they are plausible, and we talked about plausibility. The court's view of a 12b6 motion is generally limited to allegations of the complaint as well as any written instruments attached to as an exhibit or any statements of documents incorporated by its inferences. Even where a document is not incorporated by reference, the court may nevertheless consider it where the complaint relies heavily upon its terms and effect, which renders the document integral to the complaint. So the Securities and Exchange Commission, of course, could, or the court could look at documents that are outside of the complaint, or look at documents that the Securities and Exchange Commission deems as integral to its case. So there's a discussion. The defendants offer a number of reasons why, in their view, the court should dismiss the amended complaint. In short, Cohen argues that all claims against him are time barred, that the Securities and Exchange Commission impermissibly attempts to apply the Advisors Act to a predominantly extraterritorial conduct, and the Securities and Exchange Commission has not pleaded certain of its claims against him with the requisite degree of particularity. So that means these are conclusions. It might need something like what they call a 12E, which is meaning a more definitive statement, right, of the allegations. This is what they're claiming. And Burroughs joins in Cohen's statute of limitations and extraterritorial arguments, and further argues that the court lacks personal jurisdiction over him, and the SEC has not stated an FCPA claim against him. The court agrees that the SEC claims, all of which accrued more than 5 years before the SEC filed suit, and seek relief that is at least partial penal, not solely remedial. are time barred. Accordingly, the court dismisses the amended complaint and need not address defendant's remaining arguments. The court begins by providing some background on the relevant statutes of 28 USC section 2462, then turns to the parties' arguments and about how the statute applies to this particular case. So, interesting that if the court, the fact finder, finds that it's time barred, some of the defendant, which is Ripple's argument, may or may not be actually used, and so the court is going to narrow the conversation. So there's a section 2462 in Kokesh. There is the civil penalties and disgorgement, which is definitely going to be a part of the Ripple case. The court may consider a 2462 defense on a motion to dismiss. So some of the defendant's arguments could be, or affirmative defenses could be used as an argument. So the court can and should consider defendant's statute of limitations defense on a motion to dismiss. Although statute of limitations are ordinarily affirmative defenses, a court may dismiss a complaint for failure to state a claim if the allegations in the complaint, taken as true, show that the relief is barred by the applicable standards of limitation. This general rule applies with particular force to section 2462, which prohibits the court from entertaining actions that accrued more than 5 years earlier and seeking certain forms of relief. So if the Ripple, the company, can use section 2462, then, and if it falls outside of the time period, then some of these things that deal with fines, penalties, and forfeitures, right, or the SEC's allegations for disgorgement and allegedly ill-gotten gains, that if this applied, and in this case it applied to this particular case, but if it applies to the Ripple case, then that goes away. The court may consider a 2462 defense or a motion to dismiss. There we go. And then let's go to, in this case, Cohen's tolling agreements do not render timely the SEC's claim against him for monetary relief. So the Securities and Exchange Commission, in this particular case, with Cohen, entered some tolling agreements, right? The issue would be in the Ripple case, any of the FinCEN agreements, right? And to see what the courts say about the reporting, or the fine, or any of the things that occurred during that period. And the Securities and Exchange Commission will likely try to say that has something to do with the tolling, and that helps their case. But the Securities and Exchange Commission claims for disgorgement are untimely, nor all the SEC's claims timely to the extent that they seek disgorgement rather than civil penalties. The SEC argues that its disgorgement claims accrued only when, and apparently each time, defendants received ill-gotten gains as a result of the allegedly corrupt transactions discussed above. Although the amended complaint does not allege the defendants received any ill-gotten gains, the SEC contends that it is reasonable to infer that they were compensated for their participation in the alleged schemes throughout their respective tenures at Och-Ziff. Okay, the SEC thus maintains that it is entitled to discovery regarding how much of the defendant's compensation within the limitations period were derived from the corrupt activities. These arguments suffer from two fatal flaws. Interesting that Chris Lawson and Bradley Garlinghouse, if they were given XRP personally as some type of agreement to work for the company, right? What is the period in which they were given that? The other issue is, XRP having money in its escrow and using it to further its business. When did these things happen, and what is the timing of that in relationship to the suit in general? Now, the first is that the statute of limitations runs from when defendants allegedly engaged in misconduct, not when they receive compensation in connections with the misconduct. So that is an important part of this. The second is that if the SEC were correct that a claim of disgorgement accrues only when a defendant receives ill-gotten gains in connection with unlawful transaction, that would mean defendant's receipt of ill-gotten gains was an element of the SEC's disgorgement claim, which the SEC would need to have plausibility alleged in its complaint. Both the Commission has not actually alleged that because the Commission has not actually alleged that the defendants received any ill-gotten gains, the court would therefore need to dismiss the SEC's disgorgement claim for failure to state a claim. While the SEC argues in opposition to defendants' motion that it's reasonable to infer the defendants were compensated for their efforts in support of the alleged scheme, this supposition is no substitute for well-pleaded allegations. Okay, injunctive relief. Okay, and you could read that on because it pertains to this particular case. Conclusion. For the reasons stated in the memorandum in order, the court concludes that the SEC's claims are untimely. The court therefore grants defendant's motion to dismiss. And so in this particular case, these parties were the actions against them were dismissed. So as the legal general counsel for Ripple has stated that, seeing lots of tweets spreading misinformation, legal and otherwise, here are some facts. One, first line of the SEC complaint alleges from at least 2013, years before the DAO report, yet the complaint was not filed for 7 years and the day before the chair leaves office. So there is a 7-year span, and so the court will look at when the so-called allegations began, and then look at the timing of the Securities and Exchange complaint against the company. And so there is a long span that Stuart Alderati is saying that the Securities and Exchange Commission waited. Why did they wait? What was the reason for the wait? Well, all of that may not matter. What matters is, in fact, that they waited to 2020, 2 days before Christmas, to attack Ripple's company and to charge Chris Lawson and Bradley Garlinghouse and the company for actions that began at least 2013, and in their complaint they actually used the number 2012. So the Securities and Exchange Commission seems to be very time barred, because they had time, and they're supposed to protect investors. They're supposed to protect these citizens. And so, why did they wait? And then to see what their actions actually caused investors. Um, and obviously, the Ripple, the company, got notice that the SEC was going to file suit. The the Ripple, the company, notified the public because they have been so transparent to to the uh, to the people who are interested in XRP, right? This new technology, right? That they have custodial of. They alerted the public that the Securities Exchange Commission will file a suit. If they had not done that, and the Securities Exchange Commission just filed the suit without Ripple, the company, acting, then it would probably have been more devastating, right? But Ripple, the company, let the public know that the Securities and Exchange Commission, without actually seeing the complaint, had an idea that this would have a devastating effect on XRP. And so Ripple, the company, um, try to help the public know, to give them some indication of what may happen, so that the people who invested in XRP could have some idea about what they may do in spite of this, right? But the Securities and Exchange Commission, who is supposed to protect, put the market in shambles. And so you have actually two sides of this. But the Securities and Exchange Commission should know that they have already failed in another case, this particular case, this Cohen case, for being time barred, right? And they have made these allegations, and these allegations basically spooked the market. So I don't want to continue much more on this, except for the point that you should have an idea that the Securities and Exchange Commission has already failed in a case for being time barred, and hopefully in this particular matter, the Securities and Exchange Commission, who has already been experienced in a matter of being time barred, would wait so long, with the implications of hurting people who are investing in a United States technology. And so it seems to me, personal opinion, having no bearing on anything but my personal experience and those people like me who might have invested in XRP, that the Securities and Exchange Commission failed to protect people who would invest, because they waited so late. And waiting so late, they were collecting evidence, but the public was left in the blind spot. I don't like to use darkness and lightness, because, you know, everything is dark is bad and everything is light is good in this world that we live in, right? So it's a racial construct sometimes. I would say that people were blinded. The investors were blinded until the Securities and Exchange Commission comes along and alleges this. So to help you all out, again, I'm pro se, former pro se litigant. Look at the law from time to time. I hate looking at the law. I only look at it when it affects me. And in this case, the law again has affected me in some investments I made on what I deem is probably the most sophisticated, technologically um, sound uh, product, XRP, that could help speed up settlement globally, could give some type of help to the unbanked to um, help many companies who have lost money in SWIFT transactions that the Securities and Exchange Commission is basically not looking forward to the future. They seem to be like the uh, old church during the medieval periods, creating inquisitions um, on people who disagreed with the church at that particular time. And because the church deemed that the technology that they were using, uh, the uh, the thinking that they were doing was against their old belief at that particular time, they ushered in inquisitions that affected uh, the public. So large amounts of people in other religious persuasions were put to death. Many groups of people had to leave their homes. Other people had to convert, right? And at the same time, these so-called religious people then later participated in activities such as enslavement of whole groups of people because of their difference of views and their skin color. So this is like the Inquisition. This is an inquisition against people who are forward thinking, looking at the market, understanding the limitations of fiat currency in the context of a modern world. Like the world is not flat. This is an old argument. The world now is not flat. The world is global. The world is round. There are other territories. There's other solutions. There are other paradigms. And yet the Securities and Exchange Commission is trying to apply some Howey test that was written at another period to maybe keep some people who are heavily invested in fiat currency in the so-called black. There's that term again, and slow down technical innovation for some of those people, or it's just being incompetent. It's seemingly just being incompetent and vicious to technology, right? To technical thinkers. So what is the purpose of getting these technical degrees in computer science and in quantum physics, and trying to find ways in which money or wealth can be put on a ledger and be accounted for, right? What is their purpose in the context of justice and righteousness? And this is unfortunately one of the arms of the United States government. Luckily, there are the courts, right? And there are other agencies, but the Securities and Exchange Commission is being completely vicious to technical innovations. And so it is chilling the whole, it's chilling the educational institutions. It's chilling the financial institutions. And basically, with the overprinting of the US dollar, under this particular calamity and other mistakes that they have made. The Securities Exchange Commission is not attacking Bitcoin, not attacking Ethereum, even though we know that these are not necessarily United States products. And it seems like the Securities and Exchange Commission is trying to pick winners for the short term and devastating companies that could actually hold a solution to the global community. Securities and Exchange Commission is trying to pick winners. Now, I'll say this. At some point, if you're holding Bitcoin and Ethereum, and you're holding mined currencies that use electricity or fuel to manufacture that's not green, anybody in the industry who is thinking about this knows that if you're a holder of these coins, at some point you will be subjected to a energy tax or energy penalty. There is no way that you could have mined coins of a certain value, right, based on speculation without the market and policies interacting with that price in the context of what did it cost to create it? What was the pipeline? So if the pipeline is millions and millions of dollars of energy, right, then those who hold that coin or that token is the market has to interact with that. I mean, if you think that you are a Bitcoin mogul and that you can walk away without paying your fair share in the energy that was diverted from feeding people, from clean water, from clean air, and if you think you could walk away with the full bag without being taxed, something is wrong with you, right? Because that's the real theft. The real theft is the energy that it takes to create a Bitcoin in the long run. So that's my presentation. The Securities and Exchange Commission was time barred in the Michael L. Cohen and Vanja Barros defendants 17-CV-430. The Securities and Exchange Commission knows that it failed in that case. They know that it is a possibility that they will be time barred. So the question is, why did they wait so long? And why do they think that there is no penalty for waiting so long? This has been Reggie Mabry, former pro se litigant, not an expert on the law, not trying to give any legal advice, certainly not trying to give any investment advice in this time period, just talking about cases and issues that you should weigh what is happening, and hopefully I am being somewhat sensible. I don't want to hurt Ripple's company or XRP investors. XRP investors are investing in what this product can do, and investors in XRP have no stake whatsoever in the company of Ripple. I didn't invest in Ripple. I invested in what I think XRP, this dilithium crystal, could do in companies like Ripple, who could actually use this, or other companies that could use the ledger manages XRP. So with that said, I hope this was informative, and have a great day. Hopefully we can survive this pandemic, and hopefully we could benefit from this new technology and we could survive. That we're struggling to survive, so that we might be able to, and that's the reality of the issue. We are trying to survive, um, to benefit from the new technological advances of things like a ledger, things like vaccinations, things like understanding other technologies that might benefit us. So thanks again. I've been Reggie Mabry, and I hope that this talk benefits, at least in information and education, some people. Thank you.